Jim Sterling's copyright and trademark woes continue despite his recent victories, and this time he could be in serious trouble. Let's chat about it in the comments below, but first, my opinion. I'm Tarmack, and this is Feature Creep. I'm sure that most of you know who Jim Sterling is, but in the event that you don't, I need to give a quick history of the situation so everyone is on the same page of rage and fury directed at United States copyright and trademark law that I and many other YouTubers operate within on a regular basis. Jim Sterling is a game industry pundit, formerly a game media reviewer for Destructoid and The Escapist, who went out on his own by way of Patreon, doing YouTube videos and making a solid living continuing to do the reviews and industry commentary he had done to date. He's a bit of a character, telling his audience to thank God for him, and frequently displays offensive material in his videos for comedic effect. Jim's channel was the stepping off point of one of the most notable copyright issues in gaming when he was sued by a company called Digital Homicide, a studio name that just screams creativity. Digital Homicide objected to a video on their game The Slaughtering Grounds in which the game was systematically torn apart as the asset flip garbage that it was. The lawsuit was effectively rescinded recently after over a year of proceedings, but only after Sterling was required to retain a lawyer at what is likely no small expense to himself. And over the past few years, he's been a focal point or even a poster boy for the worst that the game industry has to offer, and while much of that worst is self-inflicted by choosing to go after the less professional side of the industry held within the Steam Greenlight system, the continued ire of a number of indie developers has caused Mr. Sterling little end of pain. In fact, his video on the Slaughtering Grounds was one of the very select few chosen by YouTube as examples of fair use that YouTube was willing to put their legal backing behind for the purposes of fair use on the platform. For those not aware, however, the Digital Homicide lawsuit was related to the video but not specifically the copyright infringement, which is why YouTube was not a part of the lawsuit. And after all that was done, after the lawsuit was abandoned by Digital Homicide so that they could avoid the absolutely humiliating and crushing defeat at the hands of United States fair use doctrine, Jim was hit by a different developer with a trademark violation notice. Developer Stickley Games issued a trademark infringement notification against Sterling's channel on the basis of a review video he did following their release of a game called Airport Master. And more recently, YouTube stepped in and, having reviewed the infringement claims, found them to be without merit, advising both parties that YouTube will not make any action on the trademark claim. It is worth mentioning that these are merely the most serious examples of situations that Jim has found himself in. A constant target of amateur development ire, Sterling frequently has to deal with spurious content ID claims, YouTube's auto-matching copyright algorithm, and as a result has had to come up with something he refers to as the copyright deadlock, which effectively pits one copyright holder against another to prevent less scrupulous developers from financially benefiting off of his work. Ingenious, if somewhat dangerous, but it has worked for him so far. And as long as the owners of Chains of Love don't decide to go on a DMCA rampage, I'm sure that he'll be fine. Well, those legal problems have continued with a combination this time of both copyright and trademark notifications, and he's going to have a hell of a time fighting this battle. The multinational food manufacturing giant Kellogg company has objected to the use of their brand and copyrights in the Cornflakes homunculus segment that Jim occasionally runs on his Jimquisition series. The apparent objection and claim filing to YouTube from the Kellogg company comes in the form of the visual brand, copyrighted material, and box art appearing in Jim's videos, as well as the misuse of the Cornflakes trademark. The Kellogg company is no stranger to copyright and trademark disputes, and you can find links to the cases I'm citing here in the description below. In fact, they're responsible as a result of a lawsuit victory over the National Biscuit Company, or Nabisco, for a fundamental change to trademark law over the shape of breakfast cereal, or specifically that functional design cannot be trademarked. To put a finer point on it, they were sued by Nabisco for making pillow-shaped breakfast cereal, shredded wheat to be specific, and successfully battled that lawsuit to victory. I'm not a lawyer, and some of these may sound silly, but you can look them up yourselves to verify that from a legal perspective, breakfast cereal is big business and taken very seriously. That was back in 1938 though, so for a more recent example, Kellogg's went after Exxon Mobil for their use of a cartoon tiger for advertising in the year 2000. They sued General Mills to break a trademark on the phrase Cinnamon Toast Crunch in 2004, and they went after the Maya Archaeology Initiative, a nonprofit group defending and promoting the study of Maya culture, for using a toucan in their logo in 2011. You heard that right. Kellogg's actually went after the Maya Archaeology Initiative, a group of about 12 scientists interested in conservation and cultural protection in Guatemala, which, as we all know, has clear parallels to the breakfast foods industry, all because of Toucan Sam and Fruit Loops cereal. So you can plainly see that they have no regard for the size of target, nor indeed the apparent resemblance of a trademark or use of copyrighted artwork. Now, given my own history with trademark and copyright issues and claims, as well as significant research on the topic, I would suggest that Jim has a pretty solid defense here. Much like his issues with digital homicide, most of Jim's work is clearly protected under fair use, specifically under parody exemptions, and there are fair use provisions in both copyright and trademark law. The use of these elements of copyrighted and trademark material occur within the context of a video and segment designed precisely to make fun of the material that is used, in much the same way other parody artists will make and brand their material. It also seems incredibly unlikely that the Kellogg company would be able to prove that their viewers were likely to mistake the cornflake homunculus as official marketing material. However, where it comes to copyright and trademark issues, you must never underestimate a lawyer's propensity for clever argument and pedantic understanding of loopholes. The fact of the matter is that Kellogg's has a very large, highly paid legal team. Jim may have been successful against a small group like Digital Homicide, but his resources do not compare in this case. And as we see all too often in lawsuits and legal challenges, sometimes it doesn't matter how right you are. It only matters how much money and how many lawyers you have. The story is still developing, but I wanted to get this out as quickly as possible and will gladly follow up once more details are known. Make sure to tweet at Jim Sterling all of your support with the Free the Homunculus hashtag while he deals with yet another legal challenge to his work, as by this point the amount of abuse he's suffered is well beyond the bounds of most YouTubers' ability to deal with. And please do check out a few of the links in the description to see just how ridiculous some of these Kellogg's past lawsuits have been. Let's chat about this yet another abuse of copyright and trademark in the comments below. Thanks for watching. That's all I have to say. Tarmack out.